So without further ado, let me invite up our first person to speak, Mr. Jeff Hardin. Mr. Jeff Hardin is an independent inventor associated with the Houston Inventors Association and the Inventor Rights Coalition. And please come on up, and after you, Patricia will come. Oh, you want Patricia? That's fine. Patricia, the order is not critical. Patricia Duran is also here. She's an independent inventor. As I understand, she'll be giving her testimony in Spanish, and Jeff Hardin will be translating that testimony. So we have an extra microphone here to accommodate that. And so please, let me just get this done here.
Good morning. I can say that. Mi nombre es Patricia Duran y quiero darle las gracias por la oportunidad que hoy se me concede de poder estar aquí con ustedes y hoy ustedes escucharme.
My name is Patricia Duran. Thank you for the opportunity to allow me to comment with you here today.
Okay. Soy mujer y se me considera minoría en este país y quiero una vez más agradecer a la intención de Sussex Act que emite el Congreso en solicitar recomendaciones legislativas que contribuyan a la fomentación del número de mujeres en minoría y veteranos que solicitan y obtienen patentes, pero que antes de hacer mi presentación debo empezar con la pregunta: ¿de qué sirve tener una patente si no puedo defenderla?
I am a woman. I'm considered a minority in this country. I appreciate the intent behind the Success Act for Congress to ask for legislative recommendations for how to increase the number of women, minorities, and veterans who apply for and obtain patents. But I must start with this question: what good is a patent if you cannot feasibly defend it?
Con respecto a esta ley de Sussex Act, estoy seguro de que escucharemos este tema de todos los inventores independientes, quienes son los verdaderos interesados en el sistema de patentes, quienes son el verdadero origen de la innovación norteamericana, usando a las leyes actuales de las patentes de hoy en día.
Regarding this Success Act, I am certain you will hear this theme from all independent inventors, who are the true stakeholders in the patent system and the true source of American innovation. The theme is this: women, minorities, and veterans all reside in the same category with all the other independent inventors, and this class, the independent inventors, this is the true underrepresented class. And here's why. Women, minorities, and veterans, once they receive a patent, are actually in the same predicament as all independent inventors and small businesses. With the current state of the patent law in the United States, independent inventors and small businesses cannot adequately license the patents they receive with larger financially abled entities, the represented class, nor can they enforce their patents against this class when their patents are stolen. This is because this represented class can simply bleed the underrepresented class dry, legally and financially, by taking advantage of today's current patent laws.
Por lo tanto, aunque perseguir la igualdad de oportunidades que las mujeres y la minoría y los veteranos en la obtención de una patente pueden beneficiarse de una patente, simplemente será una doctrina falsa.
So, although pursuing equal opportunity with women, minorities, and veterans in obtaining a patent is a valuable effort, if it does not coincide with equal outcome and one's ability to utilize the patent once received, regardless of the person's financial state, telling women, minorities, and veterans that they stand to benefit from a patent will simply be a false doctrine.
Después de haberle aportado la aclaración anterior, deseo contarles un capítulo de la historia de mi vida. Soy sobreviviente de cáncer. Fui diagnosticada con cáncer de mama 3 meses después, lo cual cambió todo el plan que inicialmente se había definido.
Now that I've provided the above clarification, I will tell you a chapter in the story of my life. I'm a cancer survivor. I was diagnosed with breast cancer 3 months after my daughter was born. I'm almost 3 years into my fight. After being diagnosed, I received a double mastectomy, and because the biopsy taken prior to my surgery of the suspicious lymph node adjacent to my tumor turned out to be negative, I was able to receive simultaneous reconstruction surgery during the mastectomy. 2 birds with 1 stone. But as it turned out, my diagnosis was incorrect. A second biopsy of my lymph nodes was performed during the surgery, and it was revealed that my lymph nodes, in fact, had been compromised.
El resultado fue una pura tortura irreversible y que luego tendría que volver a repetir. Durante este intento de radiaciones se completara para luego proceder con la reconstrucción nuevamente.
The result was irreversible torture, and I had to relive this multiple times. During this double surgery attempt, my mastectomy had already been completed, but my plastic surgeon was already midway into his reconstructive procedure, using fatty tissue from my abdomen to reconstruct my breasts. Because my lymph nodes were compromised, he had to suspend his work, leaving me with a diamond-shaped incision going from hip to hip, and plastic silicone sheets were to remain in my abdomen until I had undergone full chemotherapy and radiation therapy. And then I would have to come back and undergo surgery again to complete the rest of the procedure.
Entonces, el resultado final al procedimiento reconstructivo, las bendiciones de que hoy estoy viva, de que tengo 2 hermosos hijos y un esposo amoroso.
What was the end result in that follow-up procedure 1 year later? I had complications and my reconstructive surgery failed 3 times. I have not only endured and continue to suffer physical pain as a result of these surgeries, but I also endure psychological pain every day when I look in the mirror as a reminder. My scars remind me of the battle I fight, and every day is a gift. My blessing is that I'm alive, and I have 2 beautiful children and a loving husband.
Entonces, ¿cómo mi experiencia se relaciona con el tema de las patentes? Deseo que pueda edificar y contribuir a lo que hoy queremos nosotros aportar.
So how does this story relate to patents? Well, given that I endured misdiagnosis, the fact that medical diagnosis methods can be considered patent ineligible is concerning. The cure of my cancer today is merely playing a game of statistics, crossing my fingers, hoping that I fall within the percentage of people who survive and study patient populations in clinical trials. The chemotherapies I received were a result of a strong patent system, but is there something better? For example, can more work be done in immunotherapies and other discoveries? Or, as Sherry Knowles, who is also a breast cancer survivor, has questioned, are discoveries now being thrown out? The Constitution includes discoveries, and so does the patent statute. Jeff will speak more on these, but this is my testimony, and I thank you for giving me the opportunity to share my comments with you here today.
Now it's your turn.
Thank you, Patricia. And I thank the Patent Office for allowing me to comment here today. I can personally vouch for Ms. Duran and her testimony here. I'm her husband. Her being alive today and our children still having a mother is a testament to a strong patent system. And moving forward, I fear that our current weak patent system will fail us not only in medicine, but in artificial intelligence, robotics, computer software, and many other disciplines. Regarding what Mr. Rand said regarding patent eligibility, I hope to submit for the record, along with my written comments, a copy of the paper entitled Unconstitutional Application of 35 U.S.C. Section 101 by the United States Supreme Court, written by Sherry Knowles and Dr. Anthony Prosser, published in the John Marshall Review of Intellectual Property Law in 2018. This paper speaks on how the court has extraordinary judicial activism, essentially using white correction fluid on whoever discovers in the patent statute, as well as on the word discoveries in the patent clause of the Constitution. The Supreme Court's judicial exceptions to patent eligibility have led to quite a bit of confusion as to the patent eligible subject matter. Now with Section 101, Director Iancu of this office did provide his revised guidance in January of 2019. And save a congressional redo of Section 101, I welcome this guidance. It provides clarity as to what is eligible and consistency among the Patent Office. Unfortunately, the Federal Circuit expressed in Cleveland Clinic Foundation versus True Health Diagnostics, they simply are not bound by it. The opinion reads, while we greatly respect the PTO's expertise on all matters relating to patentability, including patent eligibility, we are not bound by its guidance. So first, Director Iancu's January guidance has no legal binding. And who's to say that the next director won't change the guidance? So second, the patent system should not be political. Patent law should not be malleable, subject to whomever the current president nominates for the director position, which could easily be persuaded by the donors in his pocket. For these 2 reasons alone, it is Congress who is the proper entity for addressing 101. Even though the Supreme Court in Alice said to tread lightly, lest it swallow all of patent law, it doesn't appear the lower courts are heeding to that warning, and Knowles shows historically that the High Court has seemingly written their own exceptions into law from the bench. Now, I'm aware that the Congress has members of the House and the Senate IP subcommittees currently looking into Section 101 today, and the Patent Office hopes Congress uses their framework as a guide. And these members of Congress have indeed published a framework. They published it. They sought stakeholder feedback, and if Congress does continue the path with what they did publish, they will actually be codifying what the courts have written from the bench. And there was no representation of the people in that law writing. As Knowles explains in her paper, the court, when creating these exceptions, did not refer to the statute, but they rather referred to their own previous decisions all the way back. This would be an outrage to our founders, and it would be an outrage to any informed citizen. It is Congress who writes law, and we elect them. Congress has the constitutional power to decide what promotes the useful arts and sciences for the citizenry, not the courts. The court is not an elected body. What Justice Kavanaugh wrote in Henry Schein in 2019 was correct. The Act contains no wholly groundless exception, and we may not engraft our own exceptions onto the statutory text. He's holding to the text. Simply put, the statute as it was written in 1952 and the historical reasons behind it should stand as is. The word any means any. The words or discovers mean what they say too. But because the courts have shown a propensity to make exceptions, I suggest the following language for 101. It reads, without exception, whoever invents or discovers any non-natural process, machine, manufacture, or composition of matter, or any improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. Compliance with this section is not a condition for patentability under Section 282. And I also believe that it's imperative that senators and representatives provide in the legislative history that the intent is to expressly repeal Myriad, Mayo, and Alice. And I say this here in this venue regarding the Sussex Act because of this. The Patent Office published a report in February 2019 entitled Progress and Potential, a Profile of Women Inventors on U.S. Patents. And if you look at page 8 and 9 of this report, you see this. Within chemistry, certain subcategories exhibit even higher women inventor rates. In 2016, for example, women accounted for more than 1/5 of inventors granted patents in biotechnology, 25% inventor rate, pharmaceuticals, 23%, and organic fine chemistry, 21%. Page 9, when a patent is granted, a company, university, or other entity is assigned ownership and identified as the assignee of the patent. The female share of patent inventors is trending up across assignee types, but universities and hospitals and public research organizations show the largest and most continued improvement. So given that there are many women in the medical industry, if the Patent Office is to recommend legislation to Congress that may help increase the number of women who apply for and obtain patents, it's my hope that the Patent Office would make the suggested language for 101 above part of the recommendation to Congress, as this would also help resolve any product of nature or diagnosis method ambiguities currently being judicially excluded. As shown by the testimony of my wife and her misdiagnosis, we need continued innovation in these disciplines. Now, on to minorities and women. I will quote two of them. First, a woman and a Latina, like Patricia here, Supreme Court Justice Sotomayor. In the oral argument of return mail in February of 2019, Justice Sotomayor said this of the post-grant view proceedings here at the Patent Office. It does seem like the deck is stacked against a private citizen who is dragged into these proceedings. They've got an executive agency acting as judge with an executive director who can pick the judges, who can substitute the judges, can re-examine what those judges say, and can change the ruling. To this, 2 points. One, Justice Sotomayor did not say it seems like the deck is stacked against a woman or a minority or a veteran. She said private citizen. And this is the one thing that makes the patent system resemble America. A patent is not based on the color of your skin, your gender, your race, or otherwise. A patent is based solely on the merits of the claimed invention and nothing more. And two, this reinforces what Patricia has already stated here. When it comes to patent challenges within the system Congress created with the America Invents Act in 2011, Congress unintentionally created an underrepresented class, the independent inventor and small business. And this brings me to my second minority woman, of whom I will quote House Representative Sheila Jackson Lee of Texas. Let's set the stage, shall we? June 23rd, 2011, the American Invents Act is being disclosed and discussed on the floor. Congresswoman Jackson Lee rises to offer an amendment, and she says, "My amendment speaks to the vast population of startups and small businesses that are impacted by this legislation. Small business makes up a large portion of our employer network. It is important to understand how they will be impacted as a result of patent reform." This is 2011, American Invents Act. She's on the floor talking. This sense of Congress, her amendment, will put us on notice that we need to be careful that we allow at least the opportunity of investment and investors, and that we continue to look at this bill to ensure that it responds to that opportunity. My amendment also reinforces that we do not wish to engage in any undue taking of property, because we indicate that we want to see the innovativeness of American businesses continue. And this one is key. Small businesses should be as comfortable going to the patent office as our large businesses. Then she provides her sense of Congress, her amendment, and she says, "We must always be mindful of the importance of ensuring that small companies have the same opportunities to innovate and have their inventions patented, and that the laws will continue to protect their valuable intellectual property. Without strong protection of patents, businesses will lack the incentive to attract customers and contribute to economic growth." So what happened to that investment that Ms. Jackson Lee mentioned? Well, according to the Alliance for the United States Startups and Inventors for Jobs, the USIJ, in the strategic sectors of core internet networking, wireless communications, internet software, operating system software, semiconductors, pharmaceuticals, drug discovery, surgical devices, and medical supplies, venture capital funding has dropped from being 20.95% of the total VC funding in 2004 to a mere 3.22% in 2017. The VC money is gone. I hope to include this report from the USIJ along with my written comments here. Just like Representative Jackson Lee warned with her sense of Congress amendment, Congress was put on notice that they need to be careful to allow opportunity for investors. And Congress must continue to look at this bill to ensure that it responds to that opportunity. Given the evidence showing investors fleeing these sectors, now is the time to look at that bill and its consequences. Not to lawyers, not to big business, but to the true stakeholders, the American inventors. Where are they in the conversation? And are they being left out? Interestingly, Congressman Smith, as seen in the Lee-Smith American Invents Act congressional record, responded to Congresswoman Jackson Lee, and he said this. Immediately after she sat down, he stood up and said, "I want to make it clear that my interpretation of this and its intent is to highlight the problem posed by entities that pose as financial or technological businesses, but whose sole purpose is not to create, but to sue. I am talking about patent trolls. Those entities that vacuum up patents by the hundreds or thousands and whose only innovations occur in the courtroom." And yet, even more interestingly, it was just last October in 2018 when the director of this office, Director Iancu, called the patent troll narrative Orwellian doublespeak, with mentions that the patent troll narrative being synonymous with the fairy tale throughout. He did that in Texas. Others in the industry have even come forward saying that this was just a ploy by big tech to weaken the patent system. Director Iancu said in his speech, "In our zeal to eliminate, quote, trolls and the, quote, bad patents, we have overcorrected and risk throwing out the baby with the bathwater. This must now end, and we must restore balance to our system." So where is this imbalance amongst these two groups, the underrepresented and the represented? What can you not get from a PTAB post-grant review proceeding that you can get from the traditional Article III court? If we ignore now having no stacked panel and a partial judge, a jury, full discovery, and presumption of validity that you do get in an Article III court, I'll summarize it in one word: representation. Per the 2017 AIPLA report of the Economic Survey, the estimated mean cost of a post-grant review proceeding through appeal runs at $450,000. This is how much it costs a patent holder for a single post-grant review proceeding. There are still problems with who are the real parties of interest. What about gang tackling and serial attacks, etc.? But for a single post-grant review, a patent holder, the independent inventor, will need just shy of $500,000. And with stats showing the kill rate for patents at the PTAB between 75 to 85%, no attorney is going to take this on contingency, especially when there are no damages on mere success at the patent office. This cost is on the inventor's dime. And this is just to reach the same state of reliance that previously existed on the day a patent was granted before the America Invents Act went into effect. In other words, if you don't have $500,000 to spare for a single patent challenge at the patent office, you will not find representation if you ever want to license your patent or someone does the math and challenges you, or if you want to protect your patent when someone else steals your invention. Is this a fair shake? Does a patent give women, minorities, and veterans any real benefit? Or all independent inventors, or small businesses for that matter? With a patent system like this, the question that arises, if you were to encourage these groups, women, minorities, and veterans, to get more patents, it's not, what are we doing for them, but what are we getting them into? Because they have no idea. So what is the legislative recommendation that the Success Act is looking for from this office and from stakeholders? How do we create equal outcome so that equal opportunity even presents an incentive worth pursuing? That recommendation is this: the Patent Office must recommend to Congress that if Congress wants to keep their American Invents Act system that created the represented and underrepresented classes, Congress must recognize the underrepresented class in the statute. And doing this is simple. Recognize patents where the inventors or a small business owned solely by the inventors retain ownership of the patent. These are not the so-called patent trolls. These are the true American innovators trying to start a company in their garage. They are the ones who own their patents. They retain ownership of it. Establish and identify them, inventors who own their patents, in the statute. This is the true underrepresented class. Give them preference when it comes to their patents being challenged. If it's more economical and faster to go to the PTAB, then they'll go. If not, then they'll stay in the traditional Article III court. Give them proper venue, 1400B, in places where they perform the research, for example. The face of the patent says that the patent holder has the right to exclude others. They should have that right when it comes to injunctions. Once Congress does this, the playing field will be more level. Independent inventors and small businesses and all women, minorities, and veterans who reside there in those categories, they will all have a more equal outcome. And that baby that has been thrown out with the bathwater, as Iancu mentioned, will have been safely taken out of the bathtub before the bathwater has been tossed. And the patent bargain will be worth pursuing again for the underrepresented group to which you wish to promote. Thank you.
Thank you. Thank you very much, Jeff. Thank you, Patricia, very much for your testimony today.